appeals Martin against Her Majesty's Advocate and Miller against Her Majesty's Advocate.
The appellants Sean Martin and Ross Miller were convicted of driving while disqualified. The maximum sentence which can be imposed for this offence is prescribed by statute. As originally enacted, Section 33 and Part 1 of Schedule 2 to the Road Traffic Offenders Act 1988 provided that the maximum sentence of imprisonment that a sheriff sitting summarily could impose was 6 months imprisonment. If the offence was prosecuted on indictment, the maximum sentence was 12 months imprisonment. Shortly before their cases were dealt with, following a recommendation by a committee appointed to review the provision of summary justice in Scotland, that the criminal jurisdiction of judges sitting summarily should be increased to a maximum of 12 months, the Criminal Proceedings, etc. Reform Scotland Act 2007 was enacted by the Scottish Parliament. Section 45 of that Act increased the maximum sentence that the sheriffs sitting summarily could impose for the offence of driving while disqualified to 12 months imprisonment. As a result, the appellants were each sentenced by sheriffs sitting summarily to periods in excess of 6 months imprisonment. They sought to challenge their sentences on the basis that amending the relevant provisions of the Road Traffic Offenders Act was outside the legislative competence of the Scottish Parliament. This raised a devolution issue under the Scotland Act 1988, which the Supreme Court has jurisdiction to determine. The High Court of Justiciary dismissed the appeals, holding that the increase in the sentencing power of sheriffs sitting summarily by Section 45 of the 2007 Act was within the Scottish Parliament's legislative competence. It gave the appellants permission to appeal to this court. The Supreme Court has decided by a majority of 3-2, Lord Rodger and Lord Kerr dissenting, that the provision in question was within the Scottish Parliament's legislative competence. The answer to the question which the case raises is to be found by applying the rules laid down in Section 29 and Part 1 of Schedule 4 to the Scotland Act 1988, which determine whether a provision of an act is outside the Scottish Parliament's legislative competence. They are complicated and not susceptible of being summarized in a few sentences. Put very shortly, all members of the court are satisfied that the purpose of Section 45 was to ensure that the law relating to the sentencing powers of sheriffs was consistent as between offences concerning reserved matters and otherwise, and that the change in the law which it effected does not alter the maximum period of imprisonment for the offence. The majority, however, are satisfied that the change relates to the procedure which determines whether the sheriff has power to impose that sentence, which is a rule of Scots criminal procedure. This rule of procedure is not special to the Road Traffic Offenders Act 1988. The appeals must be dismissed.
Judgment in the appeal, the preliminary application of Lewis against Redcar and Cleveland Borough Council.
The judgment will be delivered by Lord Walker.
The issue in this appeal is whether a piece of open land in Redcar, which was until 2002 used as part of a golf course, ought to be registered as a town or village green under the Commons Act 2006. That Act, which is still not fully in force, amended the Commons Registration Act 1965 so as to remove some of the difficulties in the way of registration of town or village greens. A barrister appointed as an inspector by the Redcar and Cleveland Borough Council, the registration authority, found as a fact that the local inhabitants had, for more than 20 years, used the land for walking with or without dogs, for children's games, and for similar recreational activities. But he also found that the great majority of the inhabitants using the land deferred to the golfers in the sense of holding back while they took their shots and generally giving them priority. The inspector concluded that this prevented the inhabitants' use of the land being as of right as required by the statute. The registration authority, on his advice, refused the application and this refusal was upheld by Mr. Justice Sullivan and the Court of Appeal, though another subsidiary issue was decided in favour of the applicants. In these circumstances, the single issue for this court is whether the inspector and the courts below were correct in their view that the inhabitants' deference to the golfers was fatal to their claim. This court holds that it was not fatal to their claim. The fact that the inhabitants showed good manners and deferred to the golfers would not have made a reasonable landowner suppose that they were not exercising a right to take recreation on the land. Nor is there any reason to suppose that, if the land was still being used as part of the golf course, the activities of the inhabitants and the golfers would not have continued in a state of amicable coexistence. The appeal is therefore allowed, and the Borough Council must register the land as a town or village green.
The court will now adjourn.